Division 1 is now in session.
Good morning. You may be seated. So we're here today on our case number 1CACV140416, Sobieski versus American Standard Insurance Company of Wisconsin. All of you know that you're allotted 20 minutes. Both of you know that you're allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, you're in charge of keeping track of your own time, because the clock on the podium will reflect the total amount that you have remaining, including what you may have silently decided to reserve. We've read the, well, before I go there, I should say, you probably also know that we record these proceedings, so when you approach the podium, and for the appellant each time, if you would please recite your name and the name of your client into the microphone. We've read the briefs. We've studied the record, the transcript, and the exhibits, and we've discussed the case at some length in our conference. So with that, you may proceed.
Thank you, Your Honor. May it please the Court, my name is John Weiss, and I represent the appellants American Standard Insurance Company and American Family Mutual Insurance Company. I'm going to try to reserve about 2 or 3 minutes for rebuttal. Your Honors, there are 3 aspects of our appeal. There's bad faith, eligibility for punitive damages, and then the amount of punitive damages. I'm going to begin by spending a few minutes on the bad faith claim. As the Court knows, a plaintiff in a bad faith claim has the burden of separately proving both objective unreasonableness and subjective unreasonableness. I'm going to begin with the objective component, which really is the threshold in a bad faith claim. If an insurer conducted an adequate investigation, it is entitled to judgment as a matter of law on a bad faith claim on claims that are fairly debatable. So with that legal standard in mind, let's look at what the evidence was on the objective component of the bad faith claim.
You know, Mr. Weiss, with respect, I think we're particularly interested in hearing about the next 2 components of your argument. So in terms of allocating your time.
Punitive damages and amount, Your Honor?
Right.
Certainly. Okay, well, let me spend 1 minute quickly on objective. Just the evidence that American Standard had at the time it evaluated the claim initially, it had consistent information from the claimant through Mrs. Sobieski, the claimant, Mrs. White, from the insured, Mrs. Sobieski. The information that it had when it evaluated the claim was Mr. Sobieski's motorcycle struck a car from behind when that car stopped suddenly for a pedestrian. That was the information it had. It was reasonable for it to make its claims decision based on that information, plus knowing that Mr. Sobieski had been cited. With that, Your Honor, I will go ahead and move on to the other aspects of the claim. Punitive damages, Your Honor. And in talking about punitive damages, I guess one thing to bear in mind, in large part, the evidence that was utilized to prove punitive damages was the same evidence that went to the subjective standard on the bad faith claim. So when considering the evidence, you sort of need to consider it through both prisms, both legal standards.
And how do those, in terms of the claims handling itself, the handling of this claim, how do those 2 prisms differ? How do the 2 elements of proof, required proof, differ?
Sure, Your Honor. For the subjective element of a bad faith claim, the standard of proof is whether the conduct, whether the insurer acted with such, either knew that its conduct was unreasonable or acted with such reckless disregard that knowledge could be imputed to it. On the punitive damages side, there's the clear and convincing requirement. And there we also have the sort of the proverbial evil hand crafted over the evil mind. So there is a difference. Certainly the intent requirement for punitive damages is higher than the subjective standard for punitive damages, but there's an intent requirement for both. Your Honor, for punitive damages, one of the issues that they stress is that American Standard had good claims handling guidelines, but they say it must have acted with the requisite bad intent because it didn't follow its good claims handling guidelines. Well, Your Honor, an insurer's failure to follow claims handling guidelines can be probative of a punitive damages claim only if that guideline provides a specific directive to take a specific action and the insurer intentionally chooses not to follow that guideline. Like in Nardelli. Nardelli is sort of the classic case where this comes up. There were specific guidelines. The insurer had a guideline that said, insurer, you must advise insureds of their right to obtain an appraisal. That's specific. The insurance company chose not to follow that guideline. There was a guideline that said, insurance company, if there is a complaint leveled against one of your employees, then that complaint must be considered by somebody in the company other than that employee. The employee himself or herself can't consider the complaint. In Nardelli, the insurance company chose to disregard that guideline.
So a conscious disregarding, a choice made to disregard a standard company policy.
A specific policy, a policy that says, adjusters, thou shalt do X or thou shalt not do X. Here, however, when we look at the guidelines they're pointing to, most of the guidelines are things like adjusters should accurately investigate claims or adjusters should objectively evaluate facts. Those aren't specific actions to take. Those are guidelines for the insurer that necessarily call into issue judgment calls. And an adjuster could believe they accurately investigated the facts. They could believe they objectively evaluated the facts. It's not a checklist. It's not tell insureds about their right for an appraisal. Here, the only guideline, the one that they focus on the most that I think they suggest is more specific, is the guideline relating to recorded statements. But, Your Honor, let me tell you what the evidence is regarding the recorded statement guideline. That guideline, which their expert talked a lot about, it's Trial Exhibit 7 on page 22 of the PDF on Trial Exhibit 7. That guideline, the recorded statement guideline, came out, it says on its face, in February of 2008. That was after this claim was initially adjusted. This claim was adjusted in February of 2007. So the guideline they're saying that Ms. Biddlecombe did not follow regarding recorded statements was not in effect at the time she adjusted the claim. Second, Your Honor, look at the language of that guideline. The guideline doesn't say, adjuster, you must take recorded statements of each of the following categories of people. The guideline says we should use our best judgment as to when statements are needed. A suggested guideline would be to take statements from the following, and then it lists sort of the laundry list of people.
So, counsel, is it just the case that if we keep those guidelines squishy, then they just aren't ever subject to punitive damages?
No, Your Honor, again, if there's a guideline that specifically says you must do X, but something like this, who to interview, who to take statements from, necessarily it has to be using your word squishy, because you can't really have a realistic guideline that says in every case you must take recorded statements of every single witness.
Can it say if you're going to take statements, those statements shall be recorded?
You could have a guideline that says that. American Standard did not have a guideline that said that.
It was kind of up to the decision of the adjuster.
It was up to the discretion of the adjuster, and it says so explicitly in the policy. Use your best judgment, and it says, and use your best discretion. And again, that standard wasn't even, that guideline was not in effect at the relevant time.
Understood.
So deliberate violations of explicit company policy are one way to prove the requisite evil mind. What about other ways?
Sure. Other ways, they've talked about American Standards business plans. In order for an insurer's business plans to support a claim for punitive damages, the evidence has to show that the insurer's sort of quest for profits, in furtherance of its business plans, infected the claims-making decisions. That's Nardelli. In Nardelli, the company wasn't doing well, and so it came out with a plan that said, we need to make X dollars in profits this year. And they told everyone in the company, this is what you need to focus on. Everything you do has to be focused on making sure we make X dollars in profits. They told adjusters, you must be tougher on claims. They told adjusters, you need to think about these profit goals when evaluating every aspect of the claim. They told the adjusters that your compensation is tied directly to the average amount paid on claims. Nothing like that is present in this case. There was no evidence that adjusters were pressured to think about profits when they were adjusting claims. There was no evidence that adjusters were told to decide claims based on anything but the merits of the claims. There was no evidence that compensation was tied to the amount paid on claims.
What about the business plan that, as I understand it, was given to Mr. Nick, among others, to manage the gap? Did that arguably give him an incentive, let him know that the company wanted him to oversee his people so that the company would continue to pay on the average less than what the average was paying?
No, Your Honor, it didn't. Managing the gap involved looking at data regarding industry averages for payments of similar kinds of claims and sort of using that data as a reference tool. The testimony from Mr. Nick talked about what his understanding was of managing the gap. And he certainly didn't say that my understanding of managing the gap was I needed to tell adjusters to make sure that we continue below industry averages. Instead, he understood managing the gap to mean if we're trending in one direction, figure out why. Why is it that we're changing? Why is it that we're trending in that direction? But, Your Honor, the real issue for punitive damages as far as the managing the gap is whether there was clear and convincing evidence that managing the gap business plans actually led to improper claims handling practices. And there wasn't that here. That's where the theory falls apart. This is not like Nardelli. There wasn't evidence that adjusters were told, think about managing the gap, think about it, think about it. Adjusters weren't told your compensation depends on whether you manage the gap. There was nothing like that.
Is there a case that's between, well, I will grant you that the evidence in Nardelli was pretty good for the insured, pretty good in proving up a punitive claim. Is there a case out there from any jurisdiction where the evidence was not as egregious as in Nardelli, but the court affirmed a punitive damage award? Or something below that would help us decide where the line is to be drawn?
Yeah, Your Honor, as I think about it right now, I can't think of a case off of the top of my head.
Maybe Mr. Edley knows one.
Yeah, and if that's something that interests the court, certainly we can look later and give you a one paragraph later this afternoon identifying such cases. But I don't have one off the top of my head, Your Honor.
Counsel, why is it that you thought that, I mean, what, and if you even know the answer to this question, what was it that you think drove the jury to award a $1 million punitive damage award? I mean, it seems to me that there was something that was convincing them.
Your Honor, my review of the transcript leads me to believe that it was mostly their expert's testimony, their expert who was insisting, because these policies exist, because managing the gap exists, the adjusters must have been influenced by it. He was speculating. He had no evidence of that. There was nothing that the adjusters said or did or no document pointing to that, but it was just sort of the speculation that, by gosh, these adjusters must have been driven to decide claims on an improper basis, again, without any actual evidence of that. Let me, because I do want to get a chance to reserve a few minutes, let me, if with the Court's indulgence, sort of jump ahead to the ratio issue. Well, while we think punitive damages should be reversed in their entirety, at the very least, punitive damages should be reduced to a 1-to-1 level with compensatory damages. This Court, on multiple occasions, has applied the guideposts set forth by the U.S. Supreme Court in Campbell, and this Court, in multiple cases, has established essentially a presumption that says if the compensatory damage award is substantial and if the defendant's conduct is not on the high end of the reprehensibility scale, then the Constitution won't tolerate a punitive damages award that's more than equal to the compensatory damages award. The compensatory damage award here was $500,000. That's certainly substantial. This Court has said that lesser amounts are substantial. The reprehensibility factor, the very high end of reprehensibility, this Court has said in the Hudgens case and the Campbell case also says that the high end, the highest end of reprehensibility is when the defendant causes physical harm to the plaintiff, when there's a physical assault or a threat of bodily injury, something like that. There's certainly nothing like that here.
Well, Ariano didn't find any physical assault or any physical damage to, and they awarded 4-to-1. This Court awarded 4-to-1.
That's correct, Your Honor. But in Ariano, the amount of the compensatory damages award was not substantial. The Court did not find that it was substantial. It was a 5-figure compensatory damages, so I can't recall the exact amount. I think it was maybe $80-something thousand. But in cases where the Court has found substantial compensatory damages, it has said punitives must be reduced to 1-to-1. And also, when you talk about Ariano, look at, and we move to the reprehensibility factor, look at the conduct there. The conduct there was an adjuster who, or an insurance company representative who was forging documents, who was forging the insured's name.
No, I wrote the case.
Well, Your Honor, this Court, the Court said that that's sort of between the mid-level and the high level of reprehensibility, and the Court specifically distinguished that conduct from the conduct in Nardelli, where the Court said Ariano conduct, the facts were far more reprehensible than in Nardelli. And in Nardelli, what was the allegation? The allegation was that the insurance company was driven by profits to make improper claims decisions. The same sort of allegation here. And in Nardelli, the Court said that conduct falls on the low to moderate scale of reprehensibility. Here, certainly the reprehensibility is not greater than. I mean, we submit that it's less than in Nardelli. So at most, what we have here is high compensatory, substantial compensatory damages, and reprehensibility on the low end. If we want to say it's the same as Nardelli, it would be low to moderate. Either way, the Constitution, under all of this Court's precedents, will not allow a punitive damages award here to exceed 1-to-1. And Your Honors, I'd like to reserve the remainder of my time.
Thank you.
Drowning in paper in this case. May it please the Court, my name is David Abney.
Before we begin, fun fact, we had a Mr. Garul as a party in the argument right before.
Is he the same?
He's not the same one.
Okay.
At least you knew what we were talking about, though.
Yes,
we
I
learned
did.
how to pronounce his name, so.
I always thought it was Garule, but...
Well, maybe that Garule was different than this Garul, but.
Okay.
All right.
It's always a pleasure to be here, Your Honor. I'm afraid I'm also fighting off a cold like one of the last lawyers, but the cold defeated me last night. I went to bed at 8, but I feel better today, so no longer a fight. Fight's over. There was one question you asked about a case that would involve sort of similar kinds of bad faith claim handling where there were punitive damages, I believe Zilich.
Village.
And I think the Campbell case, the famous State Farm Campbell case up at the U.S. Supreme Court, I believe that involved claims handling, but Zilich for sure. And it was, if memory serves right, it was tied, bonuses were tied to claims payouts in that particular case. The question of objective and subjective reasonableness, I think they sort of bleed into each other often. We try to keep them separate. But there comes a point, for instance, when you're handling a claim and investigating in a certain way that anybody would say, well, objectively, this is just the wrong way to do it. And then you're doing it so badly that subjectively that there's such a conscious disregard or deliberate indifference to the rights of your claimant that it should be regarded as bad faith. This case is unusual. I heard my colleague refer to the claimant had presented facts to the first claims adjuster about what happened, and the claimant he referred to there was Amber White, the driver of the Buick, as opposed to the Sobieskis, who were also claimants. Amber White was making a claim saying, well, I didn't do anything wrong, and this the guy just runs into the rear of my car, and there was a pedestrian there, and I'm not at fault. And the claims adjuster just bought that lock, stock, and barrel, 100%. Within 4 days after the accident, she says, well, Scott, you're 100% at fault. The only other information that the claims adjuster had at that time, she didn't have the police report, didn't have photos, didn't have anything else. The only other information she had was from Scott's wife, Joanna, who said, well, this is what I heard about what happened. And so you got secondhand report, and then you've got a first-hand report from an incredibly biased person who has no insurance but wants to get her car damage paid for by Mr. Sobieski's insurance company. But there were 3 other motorcyclists who were riding with Scott that day. None of the claims adjusters, none of the 2 claims adjusters ever talked with any of those, much less recorded, which would have been nice to record, but they didn't do that.
Counsel, you raised the issue of bias. In this case, I believe there was an assertion that the other 3 motorcycle riders were friends of Mr. Sobieski's, and therefore they were biased, and their interviews or their whatever they had to say wouldn't be helpful?
Yeah, they're automatically regarded as biased by American Family policy.
That's a policy of American Family?
That's what the claims adjuster said. This is how they're trained.
And yet Ms. White, who's driving the car, and we don't know if there's a person in the crosswalk, we don't know if there's, what she did, apparently. She's not biased. And I'm asking that, I mean that sincerely. The assertion was that what she had to say was merit-worthy because she wasn't biased, but the other 3 motorcycles were biased.
You put your thumb right on the problem there. From the claims adjuster's perspective, that's exactly the thinking that seemed to be going on. That because another person who's making a claim against us, who has everything in the world to gain by presenting this in the most favorable light for her, is not biased, but that the people who were riding with Mr. Sobieski are automatically biased simply because they were friends or acquaintances. And that's how she was trained, and that's how the second claims adjuster was trained, that they're automatically, because they're friends, they're automatically biased. And therefore, you don't need to get statements from them.
So then have you now advised the court that the policy of American Standard was to determine on some level that I'm not quite sure of, I mean, maybe there's a list of people, who knows, but that there are a group of people that are presumed to be biased and therefore their interviews are not taken as a policy, and yet there are other people that you want to get and that they won't be biased regardless of what their participation in the event is?
Well, on the second part, I don't know if there's a policy about that. It's beyond belief on the second point. On the first point, that there's a certain class that you don't even have to interview because they're automatically biased, that's the way the adjusters were trained, and that's what they testified to. It's laid out very neatly. In fact, almost repeated ad nauseum, and I apologize for that, in the opening brief, that's exactly how those 2 adjusters were trained. So they never took a statement from any of the independent witnesses. Plus, don't forget, if I may, don't forget there's a front seat passenger in Amber White's car that American Family never bothered to get a statement from.
On the training issue, that don't interview someone who knows the claimant is not in the materials. It's not in any of the training materials.
I think they were smart enough not to do that, but that's the adjusters both said that this is how they are trained, and they testified to that. So that's a fact for the case.
What evidence is there that supports the question we're touching on with Mr. Weiss, which is the assertion that concern for the company's bottom line drove the handling of this claim?
Well, there were business plans in effect. There was a corporate incentive program in effect, and bonuses were tied to how well you did at keeping all these claims down as low as possible.
In
Well,
2007.
let's talk about the corporate incentive plan.
Yes, at the time
Because
of this.
we've looked at them,
Yes.
and the way that I understand it, it was not until the plan updated in January, Exhibit 25, January 6, 2009, that the combined ratio was added in as a component part to the corporate incentive plan. Isn't that right?
The claim supervisor and others testified that in fact there was a form of corporate incentive program. There were bonus program in effect going right back to 2002. And for Mr. Nick, for instance, I think he was getting bonuses from 2003 to
Right.
2011.
And we have those
Right.
plans. And Exhibit 25 is the plan that showed the adding in of the combined profile as a component to the payment of bonuses. The exhibits show that prior to January of 2009, the components of the incentive plan were return on investment, more policies, more renewals, and contributions by employees.
And pardon me for just double checking on this with counsel, but the combined ratio might not have been officially a part of that, but the bonus plan was in effect and went into effect if you got a bonus, if the payments, your payments were down and you were doing better than the competition, testified that was in effect in 2007.
What's the exhibit that shows that was actually a component of the plan?
We'll look up the exhibit number and get that to you right now.
Okay, that's
If
good.
you want to go to another question, we'll come back to that.
Okay. And I guess also in the business plan, the briefs make the point, manage the gap.
Right.
Is that the egregious nature, is that what makes the business plan render the company to punitive damages?
Well, part of it is managing the gap. Part of it is what you're trying to do is maintain the difference. For instance, if American Family's paying less, a certain percentage less than its competition, you want to continue to do that.
Why?
Well, so you can make money for American Family.
So it's a profits issue.
Well, yes. It is a profit issue. You're trying to make profits off the claims handling, which you're not supposed to do. Where you're supposed to make the profits is off the premiums. And if for some reason you've set your premiums at the wrong level and your profits go down, well, that's just an unfortunate aspect of being in the underwriting business, and you adjust it for the next season. If you spin yourself into bankruptcy paying the claims, well, that's just the way it's supposed to be, because the customer who is presenting the claim is supposed to come first and foremost above anything else.
What evidence is there, though, that ties the business plan to the particular handling of this claim? I mean, this is not Nardelli. I'm not saying that Nardelli is the be-all and the end-all, that conduct less egregious that Nardelli might not qualify. But, boy, what's the link?
The link I believe, is a reasonable inference from the business plan, from the bonuses, and from all these incentives to lower costs by being as conservative as possible in claim handling, to make sure that the claimant is getting as little as possible. That is part of a business culture and business environment that our experts said was part of what was behind the claims handling here. And I believe the jury is entitled to make a reasonable inference that what happened here is as a result of this business environment that's deliberately cultivated at American Family to save money on the backs of the claimants.
Judge Johnson asked a question of Mr. Weiss, I believe. She asked, what was before the jury that obtained a $1 million? What was the evil mind testimony that was before the jury that would have had a jury give a $1 million punitive damages award?
Well, it starts with the claims handling, of course. You had no statements taken from 4 of the eyewitnesses. You took one from the 5th and believed it implicitly, Amber White. Nothing from her passenger or the other 3 motorcyclists. You immediately leaped to the conclusion she was 100% liability, although American Family went to great lengths to train its people that this is a comparative fault jurisdiction, and in a comparative fault jurisdiction, you're supposed to compare the fault of everybody who's involved in an incident. And in fact, they pushed hard in every case that you want to get some comparative fault because that will lower the amount of money that goes to the claimant. Here, they went to the utter extreme of saying, well, it's 100% comparative fault.
Well, it's 100%, fault. They didn't
right.
go to comparative fault.
Well, yeah, it
That's
is.
the problem.
I mean, it's sort of mind-boggling. When you first look at this, you say, okay, it's what's the harm in it? Well, the harm, they flipped everything upside down in this case and said, well, comparative fault is 100% against our insured claimant and 0% for the claimant making a claim for the damage to her car.
But by doing that, they ended up in what was for a while a zero payout.
Oh, yeah, which is exactly what American Family wanted, a zero payout. And then they forced the claimant to arbitration, where the arbitrator, an independent arbitrator, said the logical thing that anybody in this courtroom would say, well, both parties are somewhat at fault. Scott is 60% at fault. Amber White is 40% at fault. By the way, there's no credible evidence that there ever was a pedestrian there, and that Amber White violated the statute about making an abrupt stop and turn, and so she was negligent per se. So all of those things added in together created a claims handling that just beggars belief. Then when asked later at trial, when Mr. Nick was asked about, well, would you do things differently? He said, no. And the claims adjusters are asked, well, shouldn't you have taken the statements of the people? Yeah, I should have. And then Mr. Nick is pushed in a corner and says, why will you do it this way? Well, just because. And of course, there's more to it than that. They did it that way so they could elevate the profits. I believe that juries are entitled to make reasonable inferences from the facts. And the facts presented to the court, both by expert testimony and in the corporate incentive program and all of the other programs and policies and bonus structure that American Family had set up, was that they were interested in making sure that claims were paid out as cheaply as possible. If they could do it 30 cents on the dollar compared to what State Farm or some other companies paying, then they would be happy with that. They would be doing their duty. And that's just not the way claims are supposed to be handled.
I just keep coming back, though, to the handling of this claim. The jury must have concluded that the profit motive influenced the handling of the claim, but I guess I'm beyond declining to call up the other witnesses who, anyone would say should have been interviewed. I just don't see a link. I'm having trouble finding the link between the profit motive and the handling in this particular case. I saw your partner handed you a exhibit
well,
number.
as far as the corporate incentive program, it was implemented in 2002, exhibits 24 and 25. There's a reference to it, exhibit 25 at 6548.
Right.
And as a strategic goal of controlling severity, there's a testimony at trial. I can give you the transcripts if you'd like.
Yep.
Okay, trial transcripts for Dietz, 9/18, that's September 18, page 132, 15 to 18, page 132, and then 9/18 again, 138, pages 21.
Okay.
Pardon me, 138, line 21 to 139, line 2, and then trial exhibit 15 at 16477.
What's that?
That is part of the strategic goal of controlling severity.
Got it, yeah.
Exhibit 26 deals with bonuses for Nick, Holmes, and Biddlecombe. Nick is the claim supervisor. Holmes and Biddlecombe are the adjusters. They had quarterly updates on the bonus program. Of course, we had Nick's performance notebook where he says he met with staff to discuss their contribution to profit and hand out bonus checks. That's Exhibit 35.
When was that?
That's Exhibit 35 at 17322. That was 210-05.
Is there? Do you have anything to prove that the combined profile or claims payout was part of the corporate incentive program before the version that was marked as Exhibit 25, dated January 6, 2009.
Well, we had the corporate incentive program itself. It was, and Exhibits 24 and 25 deal with that. As far as the business plans and creating the culture and roadmap, we've got trial testimony from Huffman on, well, I'll have to look up the exact date on that one. I know it's in our opening brief.
Yeah,
Huffman's
we've got that.
testimony.
Yeah.
So part of this goes to the expert testimony, of course, and the testimony from American Family's own people that the reason that they were having these sorts of programs was to make sure that they paid as little as possible on claims.
Can you define controlling the severity for us?
Yeah, I'll try.
Severity is a rough word. I'd like to know how it applies in the insurance business.
Well, it's if you look at a claim as an adverse event, you want to control the severity of the amount of money that you're paying out, severity of the claim, by limiting the amount of the money you pay out. It's a euphemism, really. So we want to pay less. We want to control the severity. So we want to pay less. I mean, if they used plain English, it would be a lot easier to understand what they're talking about.
Controlling the severity went to the issue of controlling the severity of the impact of the payouts on the business.
On the business, right. It's not controlling the severity of anything as far as the individual people are concerned. The notion is the average amount that you pay on claims. That's controlling the severity. Want to keep it as low as possible.
And it certainly is a concern. I mean, you're
Right.
saying on claims there was a policy to control the severity.
Right. Right. Which is not how everything is upside down at the company. I believe the jury is entitled to say, okay, the explanation for what happened here, the motivation for what happened here, is that the company must obviously have had a goal of keeping this claim as low as possible. And of course, in this case, as low as possible meant not paying out a penny. Forcing the Sobieskis, when they were in evident distress, to go through an arbitration and then to go to trial. And here we are now in year 9 after the accident, and it's still unsettled what happened. Part of what makes this particularly bad is that American Family knew from the start just how bad the injury was. The very first day, I mean, Joanna reported it to her insurance agent, that her husband had been involved in an accident, his leg was crushed, and he wouldn't be able to walk for a year. And then over the next couple of days, more information came into the first adjuster that it really was bad. There were going to be multiple surgeries, there was going to be a long period of rehabilitation, no ability to work. The Sobieskis testified that this had a dramatic impact on their life, not only the emotional upset, but the financial stress that all this caused. And it all could have been avoided if American Family had taken a realistic, objective look at this and had not acted to serve its own interests. And I think the jury made definitely the right call here.
Does the obvious distress that the family was under, the hospitalization and the upside down on expenses and whatnot, does that go to the constitutional analysis?
I believe it also fits in with reprehensibility. I mean, there is not a bad actor doing physical bad things to somebody, but you do have people who are suffering terrible physical effects and then financial and emotional effects that are being put through the ringer because the insurance company wants to save a few dollars. And in the end, probably with their attorney's fees, they're going to pay a heck of a lot more just if they litigated this. If they were completely successful, they'd pay more than they paid on the claim. It just gets crazy.
What's the best case for that proposition on the constitutional analysis, where the fact if the jury finds that there was an intentional evil mind-driven act, the fact that the plaintiff is in physical distress, emotional distress at the time might.
Well, I think it's believed it's an indifference among the Gore reprehensibility factors, and this may take me slightly over because they just take up a few seconds each, but indifference to or reckless disregard or health or safety of others. I believe when you consider emotional distress and upset, that matters. Financial vulnerability is a huge factor here. They got hit at just the wrong time. You know, you pay money for insurance, you'd never expect to use it, you never want to use it, and then the time you get to use it, it just breaks your heart when the insurance company says go away. Repeated actions or an isolated incident, this seems to be part of a corporate culture. That's the explanation that really makes sense, and I'm sure that's part of what the jury was relying on. And then the result of deceit. You had Philip Nick on the stand, Philip Nick in his deposition saying, bonus? What bonus? What are you talking about? And then at trial, well, there's the proof that there were bonuses, in fact, going on. It's a terrible case. The claims handling alone, I believe, Your Honor, would be sufficient to justify an award of punitive damages larger than the one that was awarded. But the corporate culture behind all this is what's really sickening. I've run through my time.
Thank you.
Thank you so much.
John Weiss again for the appellants. Your Honors, let me just touch on a few things that came up. First, Judge Johnson, you asked me if there was a case sort of below Nardelli, and while I was sitting there, I was looking through the cases that we cited in our briefs, and one of them that may fit the bill there was the Knoll case, Knoell, which was it was a U.S. District Court case out of Arizona, where the court said that keeping statistics on the resolution of claims and looking at the bottom line, those are reasonable procedures, particularly where the plaintiff offers no evidence that the insurer's conduct ever resulted in the denial of a legitimate claim. So that's one case I would refer you to. There was some discussion of the Zilich case, and be clear, the facts in Zilich were every bit as egregious as Nardelli. In Zilich, there was a corporate-wide deliberate practice to underpay claims nationwide. That was the directive, underpay claims. Promotions, salaries, et cetera, those were all tied directly to meeting the profit goals. Here, when we talk about the profit goals, you've looked at the policy, so you've seen that bonuses were tied to things like, renewals of claims, customer satisfaction, that sort of thing. When the term that's come up a few times, that combined ratio, which didn't come up until later, but combined ratio, to the extent it looked at profits, it wasn't looking at an individual adjuster's contribution to profits or individual numbers relating to that adjuster. Combined ratio looked at, is the company as a whole profitable? If the company as a whole is profitable, there's going to be more bonus money available for our employees.
Does that fall into that category of every 1% matters?
No, Your Honor. Your Honor, in any company, whether an insurance company or any other company, if there are profits available, there's nothing wrong with the company, the insurance company, sharing those profits with its employees. But the company is not, like in Nardelli, telling employees what you need to be thinking about is profits. That's what you need to be thinking about. All of the testimony, every single adjuster who testified said, what was stressed to us over and over? Pay what we owe. Pay what we owe. That's what was drilled into us. Pay what we owe. Does that mean don't overpay claims? Sure, it means don't overpay claims. But insurance companies don't do anything wrong or insidious. If they don't want to overpay claims, they're not required to overpay claims. My time has expired unless there are any other questions.
Other questions? Thanks. Thanks to all the lawyers for their time and your work. We'll take the matter under advisement and issue a decision in due course. We stand adjourned.